Inheritance. It is a word that is deeply complicated, and not just that, it's also a topic that is uncomfortable to talk about. And that's probably because we're uncomfortable with the idea of our own mortality. And for those that are inheriting, we're uncomfortable with the idea that our parents may not be with us, will not be with us forever. I'm Mathew, and this is Big Decisions on NDTV Profit. And on today's episode, we're going to talk about this very key issue. But we're going to focus on the rights of the woman. Because in conversations that we've had leading up to this episode, we've discovered some deeply troubling stories. In fact, we spoke to a few young women, and these are some of the things that they had to say.
So I'm very well aware about the inheritance law, but I don't think any of my dad's property will come to me because, that's exactly how it has been happening over the years. My mom never asked for it. My mom never asked for it. So ultimately, it's like a thing that, dad's property goes to your brother.
My father had passed away a few years ago, and my extended family is thinking of selling off our ancestral land. My uncle, from my father's side, pointed out to me that since I'm a daughter, I don't have a share in the ancestral property, like my brother does.
My father tried to ensure my financial security by making a will, but because there wasn't really any proper phrasing of the will due to inadequate assistance, there were a lot of dual conditions, and it led to a lot of the will's condition being declared void in the court. So most of the assets went to my brother.
So I have a brother with two siblings, and my brother and his wife used to live with our parents in our ancestral home. Now both my parents have passed, and I have been wanting to move back to my ancestral home or at least visit, but my brother and his wife will not allow it because they say that since it's an ancestral home, it doesn't belong to me. I don't inherit it, and I don't know if I can even challenge it.
I'd like to break this up into two parts. In the first part, we'll talk about the legal rights of the inheritor with a focus on the woman. And in the second part, we'll talk to you about what you need to know from the financial planning perspective. Joining me now is Bijal Ajinkya, partner at Khaitan & Co. Bijal, thanks so much for taking the time.
Most welcome.
Why is this such a complicated, troublesome, uncomfortable conversation?
So I would say that you have the law on one side, which I would say is extremely progressive, and our law has always provided for rights for a woman, be it you a daughter, a wife, or for that matter a mother. However, from a societal perspective, a daughter or a woman is always seen as someone that, as we've always said, pariah. So, after she's married, she belongs to the husband's family, and to that extent, from a legacy perspective, it is always the son who's actually going to take over. And I would say that it's interesting that Indian families, more often than not, they somewhere believe that from a philosophical as well as a spiritual perspective, talking about death is something which is like really bad. And even as, even for the inheritor, really to talk about, their parents not really being there or the in-laws not really being there becomes a very tricky situation.
Because what are you implying?
Absolutely. Are you implying that, I want something, or are you really looking at a situation wherein, you are ready to actually move on? So it becomes a very tricky conversation. However, it's interesting to really see that the law has been progressive, and to that extent, it's only wherein the society on the whole needs to be progressive. And really knowing women's rights is an important situation.
So let's talk about the law, and let's talk about how it treats men and women. Is there a difference in the eyes of the law between a man and a woman when it comes to inheritance?
So I would say that, when you're looking at a daughter or a son, right, for that matter, you look at the Hindu Succession Act, we look at the Indian Succession Act, they've always provided for the son and the daughter to actually take in equally. It was only in the year 2005, vis-a-vis ancestral or co-partnership property, wherein a daughter was considered an equal co-partner to a son.
Can you explain this in very simple terms? We're talking about ancestral property. Would that be something that not your father, but your grandfather or someone before him?
That's correct.
Or your grandmother at that?
Yeah.
Basically, your father's or your mother's parents built something and it passed on, and that becomes ancestral.
Absolutely. So, when you're looking at a situation like in India, it's very common to do joint businesses as a family unit as a whole. So, you don't really look at that, okay, this is my brother, this is my sister. And you've had situations in grandparents' generation, between the, 3 or 4 brothers, they would be doing a joint business. And there was never really a demarcation as to whether this asset which you have invested really belongs to you. It was all considered as one unit in itself. You never saw like your brother as a different family. And to that extent, something like that which is passing on through generations is considered as joint family property, or for that matter, ancestral property.
Okay, so it's not just a building, it can be assets, it can be various other
It can be anything.
things.
It could be business, it could be a building. Currently, given the fact that there is so much of, old constructions really coming down and new ones really coming up, you do see a number of legal documents seeing the rounds, because today no builder wants to pick up a building which has actually a family dispute sitting within it.
Right.
So to that extent, you would be taking the approval of all the co-partners, and now with the
How do you
change in
define a
law.
co-partner? So just this is a legal term that is used, but how do you describe a co-partner? What is that?
So a co-partner is a person who belongs to a family. It's of course more dealt with in Hindu law. And to that extent, if at all your father could either set up a property and call it as a joint Hindu family property, and in which case post 2005 the daughter and the son actually taken equally. If it was prior to 2005, it was different. However, with the Supreme Court decision, irrespective of when the co-partnery property was set up, so long as the father or the grandfather decided that this is now a common hodgepodge to be meant for the benefit of the entire family in itself, to that extent it is considered as co-partnery property.
Okay, so what that means is that even if, and suppose, let me give you a hypothetical situation. It's me and my sister, and my father has decided that this ancestral property he wants to distribute, or he wants to give through a will to his son. It can be challenged by my sister because the law states that she should have an equal share.
That is correct.
Okay.
That is correct. And which is where you are seeing a lot of situations where families, because they want to be extremely clear on succession, and obviously in a situation where both son and daughter are married and they do have their own families, it becomes very difficult, if at all, that particular co-partnery is actually running a business, right? So to that extent, we are seeing a number of situations where families are looking at a partition of these Hindu undivided family. So you're partitioning it out, and not necessarily from the perspective that you don't want your daughter to actually benefit. It's more from the perspective of bringing in that clarity vis-a-vis what the son and what the daughter are really inheriting.
Is this only with Hindu undivided family, or is this with all ancestral property?
So I would say that it is more vis-a-vis Hindu properties, because the entire concept of ancestral property is coming in under the Hindu law itself.
Is there any distinction that you would need to pay attention to in the Hindu law vis-a-vis the common law? Is that right? Am I saying the right word? Is it common law?
Okay, so in India, we don't have a uniform civil code so far.
Sure.
So we don't have one law which applies across India. The law which we have in India, it essentially depends on the personal law which you really belong to.
Okay.
So if you are of the Hindu faith, you do belong to the, your succession will be as per Hindu succession law. If you are a Parsi, as per Parsi succession law. If you are, say, a Christian, under the Indian Succession Act, and so on and so forth. So it really depends which sect you really belong to. Of course, there is a move to actually bring in a uniform civil code, but I think that's a question of time.
It's a question of time. Let's talk about issues that you have come across, and of course we've laid out some of those aspects, and I think you pointed out a very important part at the start, which is that the law provides a certain set of rules, but then society looks at these things differently. I'm sure over the course of your career you've come up with, or you've come across several instances that will help us, help our listeners and viewers understand this concept of inheritance. What, according to you, is the most startling case that you've come across?
Well, I would say, I mean, many, and of course, it really depends on, it really differs from family to family. If we're looking at, daughters' rights in itself, we've seen situations where, let's assume, the daughter is living in India and the, son is outside of India, and perhaps the daughter is the one who's really looking after the parents in itself, may not be necessarily living with them. We've seen situations where the daughter has actually moved all the assets to her name, leaving actually her son high and dry. Her brother high and dry, right? So you've seen both of those situations. And I would also say cases wherein, especially in a joint business, wherein you do have a larger family in the mix. In a situation where, and this would be more important in business families, like if the wife is not really a working person in the family business, she may really be looking after the home and really building up the personal family in itself, which is a very, very important job. And in a situation where, let's assume her husband passes, then in that case, often we've seen situations where the wife is absolutely clueless of the family assets in itself. And to that extent, extremely important for families to really consider, creating a register of assets and liabilities, because we've often known, some creditors who were absolutely, unaware to the family in itself, really pop up when somebody passes away. So to that extent, whether it's a business family and creating some level of, asset base for the spouse becomes extremely important. When you're looking at, daughters in itself, very important to consider that, it could be a situation wherein the daughter feels uncomfortable really asking about it. Not necessarily she is in the best of financial position herself, but she just feels, an emotional bond to her family, wherein she feels that if I ask this question, is there going to be a second guess about my real intentions? However, I would say that most families today are really looking at it clearly, getting their children, on the table, explaining to them what their real wishes are, and to that extent, really looking at a division of assets which really best suits the family needs.
But there are a few cases that we came across, anecdotal cases that are quite troubling, to say the very least. And I'd like to ask Bijal about how to deal with certain situations like this, because I think that they would be representative of cases that a lot of other people might be facing. So Bijal, I'd like to start with the first one, which is that there is no will that was made. The parents have passed. But the brother and his wife are living in a property. The sister is not allowed to enter, and she does not know whether she has a right to that property. How does one deal with a situation like this?
Sure. So one, I would say that given the fact that the parents passed without a will, most important to note that the sister does have an equal right as the son in the property. Now, it is very common that, you may not actually have a will. However, what is important to note that for the transition of assets, or the transmission of assets from the parent's name to the child's name, even if at all it is the son, they would require a letters of administration or a succession certificate from the court. Now, when you apply to the court for a succession certificate or a letters of administration, it is extremely important for the person who's actually making the application to get a no objection from the heirs of the parents.
Right.
And these are heirs who are heirs under succession laws. So it doesn't matter even if they had a will and they had actually put in someone's name, let's assume they had put in the son's name, even then the daughter actually has, needs to be asked for a no objection to go ahead with the execution procedure.
Even if there's a will?
Even if there is a will.
Okay.
Now, that is her first point in call, wherein she can essentially say that I object, I really want to actually see the will, or if there is no will, if you claim that there is no will, then in that situation, under law, we both inherit in equal proportions.
Right. But in several cases, I would assume that people simply don't go for that process in court and they continue to live in a property. In that situation, what is the recourse?
I would say in that situation, the most common recourse to really undertake is the fact of you actually going to the society and filing a letter there to essentially say that, look, we are equal owners and I would also like to assert my right. if at all the sister would like to, she can actually go to the courts in a petition to say that I would like to also live there and I want a partition of this particular property to be undertaken.
But it's a complicated situation.
I would say it's definitely complicated, but it does get her brother to actually come down on the table and negotiate it as such. Because the easiest thing for the sister to really get is an interim order from a court. That's not really difficult. And in which case, the brother could be asked that, okay, we are going to keep it status quo, but you will not be allowed to live in the property, which is the worst which they could really get.
Right.
Yeah, so in most situations, and I think what is important here is for the daughter to be aware of what the properties are.
Sure.
Now, she may just be aware of this real estate. Now, it's important for her to know as to whether the real estate has actually been gifted by the parents to the son in their lifetime. If it has, then of course, there is nothing which she can really do about it, unless of course she can challenge the fact that this gift was made under a duress.
Okay.
But it would require a lot actually to be seen as evidence,
Yes.
because how do you really prove that somebody is forced?
Sure.
So unless there are letters to really show that, you know, my parents are mistreating me, you know, your parents are mistreating me, but I don't have a choice but to live with your brother, etc. Unless there is something like that, it does become extremely tricky.
Okay. But post the fact, you have legal recourse, and we've discussed that. The other one has to do with ancestral land, in which case the uncle is saying, you know, as a daughter, you do not have access or you do not have rights to ancestral property. That is patently false.
Absolutely. Given the fact that her father would have been a part of that particular ancestral wealth, a daughter takes equally as the son from the share of her father itself. So to that extent, the share of in their ancestral property, which the father may have inherited himself, right? Because from his father or his own grandfather, the daughter herself does have an inherent right in it. Now, of course, you know, in a situation where that particular property is going in for a redevelopment, etc., very important to note that the daughter's signatures would be required to be actually taken before the hammer is actually put on the building.
Again, a no objection certificate.
Absolutely.
But in that case, even if there's a no objection certificate, she would still have a right to the developed property.
So it really depends on how that particular agreement for redevelopment is undertaken. So more often than not, it's really a no objection come a family settlement.
Sure.
In which case, she does need to read the fine print to understand as to what she's giving up and what she's getting in return.
Is it better to seek legal help in these situations?
Definitely, definitely, because more often than not that these documents are a little complicated, and if she is really giving her no objection, the question is, what is she really getting in return? If she says it's for nil consideration, right, which is where I don't want anything, then she's totally out. But if at all it's a situation, you know, you will often see situations where they will actually pay her an amount and say that now in the redeveloped building, we are going to be getting X number of flats. And in those X number of flats, only these particular family members have a right. Now that's all put up in that particular agreement, in the family settlement itself. So it's important, you know, for her to read the fine print.
Okay. The third case that I want to discuss is the absence of a will, and this is slightly complicated because what was pointed out is that the parents were split, but they were not divorced.
Okay.
The mother passed. The flat was in the name of the mother, and the daughter does not know what her rights are in this situation. My interpretation as a layperson is that both the father as well as the daughter had right to the property. So how do you proceed with that?
Yes. So I would say here, you know, given the fact that the parents are separated and they are not really divorced, when a woman passes away, under most laws, the husband as well as the children inherit. Now there may be differences in the ratio of distribution depending on the law which that you know, the woman is actually subjected to.
Can you explain why that is, or what the nuances of that are?
Yeah. So as an example, if you're looking at say a Hindu law, or if we are looking at the Indian Succession Act, in that case, the husband and the children, they all inherit in the woman's property in equal proportion.
Okay.
If we are looking at the Islamic law on succession,
Sharia law, right.
the Sharia law, then in that situation there are variant grades, because it's a very interesting law wherein they are providing for the larger family itself.
Okay.
So, you know, the mother, her parents or her husband, the, you know, her children, children's children, each of them get a particular share. So it's not really equal, but they do have a specific ratio. So depending on whatever, you know, religious faith the mother really belonged to, that would really, you know, take care of a succession. However, having said that, the fact is that the daughter as well as the husband, in spite of him being separated, they both have an entitlement in the absence of her having a will. And the question is that how does she really know the assets? And that's something for her to really understand the assets which were there, you know, looking at her last balance sheet filed.
Sure.
You know, you have income tax returns which are really filed, or of course, you know, the family accountant or well-wisher who's actually kept a list of those assets.
Okay. How important is a will? In the situations that you have seen, one would think that it's of paramount importance, right? How complicated is it if you don't have a will, in your experience?
Okay, so it's very interesting to really see that when you have a will, you have a way.
Right.
Right? Okay. So whether it's a contest or it's a pure succession. Now, in a situation where you have a will, I think the beauty really is that you very clearly carved out the succession vis-a-vis each of your inheritors.
Sure.
When you don't really have a will, it's going by the succession law, and to that extent, irrespective of what the asset is, it's just going to be divided amongst the inheritors. Now let us take an example of a home, right? You don't want a situation wherein you have like a married son, a married daughter, you know, the wife all living in, you know, having a claim on that particular property.
Correct.
So the beauty of a will is that you can very clearly carve out that, okay, this particular property, I would like it to be for my wife, or to be, you know, after my wife, maybe for my children in equal proportions. I may want them to sell the property so that, you know, there is no dispute, because finally, what is it which your family wants? Right? You're not really looking at passing on wealth. You're really looking at passing on a legacy of values.
Yes.
And to that extent, if you do want your son and daughter to actually, you know, have that relationship post the parents' lifetime, very, very important for there to be absolute clarity on the distribution of assets.
Let's talk about the last aspect, which is once a will has been received and you're trying to execute this. I've heard, again, anecdotal evidence that this can also be a painful process, that getting the probate, is that what it's called?
That's right.
From the court, so that is the approval of the court.
That's correct.
Can be time consuming.
Yeah, so it can be time consuming of around, you know, 6 months, 6 to 9 months. And of course, we are assuming it's a situation of no contest by the real heirs under, you know, succession laws. Or it could be a situation that you've taken a will to a court, but the person who's deceased, who's called a testator, he's actually written a subsequent will. Right? So the reason of a probate is really giving a stamp of authority that yes, this is the final will of that particular deceased and it's ready for an execution. Now, whichever way we really look at it, whether you have a will, you will go in for a probate. If you don't have a will, then in that situation, like if the person who's passed away has lived in, say, Bombay, Calcutta or Chennai, these are the presidential towns, and a succession certificate or you know, letters of administration is compulsory in these particular you know, jurisdictions for the transmission of assets. If you are living in a place outside of these 3 presidential towns, then in that situation, if the value of the property is high, then any of those, like if it's a shares of a company or a society's, you know, where apartment which we are transmitting, they, for their own good housekeeping, will actually want you to approach, say, the Delhi High Court or whichever, in order to actually ensure that there is no dispute and the company or the society is not dragged into a family dispute.
Fair point. You know, I think we've delved into a lot of very important subjects today, but at the same time, because this is such a complicated issue, Bijal, I'm sure that people will have questions. So what I will say is that though this conversation, this very important and lovely conversation has drawn to a close, if my viewers and listeners have questions, they can send them to us on any one of our social media platforms, and we'll try and get Bijal to answer them at a later date. Bijal, thank you so much for taking the
Most
time.
welcome. Thank you.
It's been an absolute pleasure bringing you this episode of Big Decisions. Like I said, if you've got questions for us, send them to us on any one of our social media platforms, and do stay tuned. We'll be bringing you a lot more content just like this over the course of the coming weeks. This is NDTV Profit.